Have you ever considered the influence of law on development's trajectory? Is it a mere mirror to a society's socio-economic growth, or an active sculptor? The convergence of law and development presents an intriguing domain, prompting us to delve into these inquiries. Have you ever questioned the relationship between law and development? The significance of this bond stems from the acknowledgement of the pivotal role legal structures and procedures play in endorsing and maintaining economic, social, and political progress. Let's first focus on the rule of law. A robust legal framework is indispensable for fostering an environment conducive to development. It offers the necessary guidelines for society's orderly conduct, providing stability. Next, protection of rights. Legal systems guard individual liberties, preserving the dignity of each citizen. These comprise civil rights, property possession, and justice accessibility, which are vital for human progression. Following that, governance and accountability. Law promotes good governance by implementing transparency, accountability, and public participation methods, fostering an integrity-filled culture. Furthermore, economic development. Legal structures are pivotal in facilitating economic activities and entrepreneurship growth. They set the rules for businesses and investors, stimulating economic expansion and employment production. On to social development. Laws can tackle social issues such as poverty and inequality, promoting social inclusion by guaranteeing equal opportunities for all, particularly the marginalized. Environmental sustainability also comes into play. Environmental laws are crucial for sustainable development, protecting natural resources and battling climate change. Lastly, international cooperation. Law forms the groundwork for international collaboration on development matters, enabling nations to collectively confront global challenges. In conclusion, law and development are interconnected as they offer the necessary institutional and normative foundations for nurturing inclusive, sustainable, and equitable development outcomes. As we progress in this discourse, we shall explore the core theories of development that govern the convergence of law and development. Welcome to Section 3, the intersection of law and development. As we journey further into this multifaceted crossroad, understanding the primary theories guiding societal evolution becomes essential. These theories are pivotal in shaping our perception of development and have significant implications for the interpretation and implementation of laws. Firstly, we consider the modernization theory. This theory suggests a societal transition from traditional to modern stages of development, with Western societies as the model. It underscores the importance of economic prosperity, technological advancement, and societal transformation. Following this, the dependency theory offers a counterpoint, arguing that underdevelopment in certain societies results from their exploitation by developed nations. This theory highlights global dynamics and their influence on national development trajectories. Subsequently, the world systems theory presents a broader view, visualizing the world as a complex web of socio-economic systems, emphasizing global economic interdependence. In contrast, the structuralist theory focuses on a nation's internal economic structures, proposing that these structures need modification for equitable development. Finally, the human-human development theory advocates a shift from a purely economic perspective to a more holistic approach, considering aspects such as education, health, and quality of life. Although these theories varied viewpoints, each enriches our understanding of development and its intricate association with law. They shape the guiding principles of law and development, which we will explore further in our subsequent discussion. Welcome to Scene 4, Further Perspectives on Development. As we proceed with our exploration of development theories, we probe deeper into a selection of enlightening viewpoints that augment our comprehension of development and its intricate liaison with law. We initiate with the post-development theory. This construct questions the fundamental concept of development, proposing alternative interpretations of progress and change. It disputes the Western-centric paradigm of development, contending that native cultures and knowledge systems present comparably valid and often more sustainable avenues to societal progression. Next, we scrutinize the feminist development theory. This viewpoint accentuates the critical role of gender in development, advocating gender equity and women's empowerment, maintaining that full development is unattainable without equal opportunities for all. Lastly, we examine the sustainable development theory. This construct highlights the necessity of development that satisfies present needs without jeopardizing the capacity of future generations to fulfill theirs. It supports a balanced strategy that amalgamates economic growth, social equity, and environmental conservation. These supplementary theories don't only amplify our understanding of development, they illuminate its multifaceted relationship with law. They underscore the necessity for laws that are receptive to varied perspectives and capable of nurturing sustainable, equitable, and inclusive development. As we advance, we will probe into the guiding principles that shape law and development. Scene 4: Fundamental Theories of Development. Law doesn't exist in isolation, but is influenced by guiding principles that shape development strategies, programs, and initiatives. Let's explore these principles and discover their role in sustainable development. Sustainability, the key element of development, emphasizes meeting our needs without compromising future generations' ability. Equity and social justice aim for homogeneous distribution of development advantages across society, leaving no one behind. Participation and empowerment integrate local communities in decision-making, fostering self-reliance. Rights, an integral part of development, ensure respect for every individual's dignity and rights, irrespective of their socioeconomic status. Inclusivity involves all societal members, particularly the marginalized and susceptible, in the development journey. Accountability and transparency keep those in power in check, promoting a clear and comprehensible development process. Lastly, the holistic accepts development as multifaceted and interconnected, focusing not only on economic prosperity, but also on social and environmental welfare. These are not mere theoretical constructs, but practical guides for law creation and execution, as we will illustrate in our upcoming Brazil case study. Scene 5: Law and Development Principles in Action. Take the instance of Brazil, a nation that has experienced a vigorous connection between law and development, rooted in development principles. In the closing decades of the 20th century, Brazil found itself in a struggle with rampant deforestation in the Amazon region. Acknowledging the necessity to balance economic expansion and environmental preservation, the government instituted a collection of legal strategies to mitigate deforestation. These included the Forest Code of 1965, updated in 2012, which required Amazonian landowners to preserve a certain ratio of their property as forest. Initially, this law faced considerable opposition from farmers and landowners who believed it curtailed their revenue potential. Yet, with the progression of time, the incorporation of satellite imagery and the adoption of stricter enforcement measures, the legislation began to yield beneficial outcomes. The diminishing deforestation rates powerfully illustrate the effectiveness of legal frameworks in promoting sustainable development. Scene 6: The Case of Brazil. To imply that the law has resolved all of Brazil's environmental challenges would be an oversimplification. The nation continues to confront issues such as unregulated logging, land rights conflicts, among others. Yet these challenges underscore law's potential as a catalyst for growth, while highlighting the complexity and obstacles inherent. So, what insights can we glean from this case study? Firstly, developmental principles actively shape societal trajectories, intervening in economic and social. Secondly, the intersection of law and development requires a delicate balance. Legal decisions must consider a gamut of factors, from economic implications to social equity, environmental sustainability, and cultural values. Achieving this balance often necessitates careful negotiation and compromise. Furthermore, while law can facilitate development, it is not the panacea. Legal frameworks are most effective when integrated into a comprehensive strategy that includes robust institutions, sound policies, and active public involvement. In conclusion, law and development philosophy compels us to acknowledge law's potential as a catalyst for positive change. It urges us to thoughtfully consider how we can leverage legal systems to promote sustainable growth, protect human rights, and build society. This journey invites not only legal acumen, but also a deep understanding of the nuances of human societies. We journey now to Nepal, a culturally rich nation grappling with multifaceted development challenges. These struggles shine a light on the intricate dance between law and development. Firstly, Nepal's need for a robust legal framework is apparent. Laws concerning land tenure, property rights, contract enforcement, and business regulations aren't merely conducive for investment and entrepreneurship, but form the bedrock of economic prosperity. Secondly, social injustices such as caste-based discrimination, gender inequality, and marginalization of minorities and indigenous groups are prevalent. Legal reform and interventions become indispensable tools for ensuring equal rights, addressing historical wrongs, and fostering inclusivity. Thirdly, the shadow of political instability and internal conflict looms large. Legal mechanisms for transitional justice and reconciliation are key to healing, establishing accountability, and cultivating sustainable peace. Fourthly, Nepal's rich biodiversity faces environmental threats. Vigorous environmental legislation is pivotal for conserving ecosystems, endorsing sustainable resource use, and mitigating environmental degradation. Fifthly, corruption, weak governance, and lack of transparency persist. Strengthened legal frameworks promoting accountability, transparency, and anti-corruption measures are vital for fostering good governance and public trust. Sixthly, despite progress in human rights protection, challenges to freedom of expression, assembly, and access to justice persist. Upholding human rights principles legally is essential for safeguarding individual rights and dignity. Lastly, Nepal's diverse cultural landscape implores recognition and integration of indigenous and customary legal systems into the broader legal framework, promoting legal pluralism and respect for cultural diversity. Undeniably, law and development play a paramount role in Nepal's journey towards economic prosperity, social justice, environmental sustainability, peace-building, good governance, and human rights protection. Legal reforms and interventions, though complex, have the potential to address Nepal's development obstacles and uplift its populace. This narrative, akin to Brazil's, attests to law's transformative potential, yet underscores the nuanced understanding required on the path to sustainable development. Let's delve into Scene 8, where we delve into a less examined facet of law and development, its criticisms. While the field's transformative power is undeniable, it isn't free from critique. First, we encounter the Western bias critique, which suggests that many law initiatives, oblivious to the socio-economic realities of countries like Nepal and Brazil, are modeled on Western paradigms. Next, the criticism of elitism and exclusion posits that these often serve the interests of elites, overlooking the marginalized. Then, there's the allegation of limited impact, questioning the effectiveness of law and development interventions in effecting substantial societal and economic change. The legal formalism critique warns against an overly rigid approach that doesn't consider socio-political dynamics, potentially impeding legal reforms. The fifth critique, lack of participation and ownership, suggests that such initiatives often neglect to involve local communities and stakeholders. A section of critics also sees law and development as a promoter of a neoliberal agenda, advocating market-based solutions, potentially amplifying social inequalities and environmental degradation. Lastly, the instrumentalization of law critique warns against using the law merely as a tool to achieve narrow development goals, thereby possibly overlooking broader implications. These critiques underscore the need for context-sensitive, participatory, and comprehensive approaches to promote sustainable and inclusive development outcomes that respect diverse legal traditions and socio-cultural contexts. Ultimately, the goal is to leverage law to create a fairer, more sustainable world, hence the need for critical, inclusive, and context-appropriate engagements.